Good afternoon, Ms. Park. I'm sorry, how do you pronounce your name?
Pangarker. Good
Pangarker.
afternoon, Chief Justice.
Are you
And
comfortable?
congratulations on your appointment.
Thank you.
And good afternoon, Commissioners.
You comfortable over there?
Yes, thank you.
Right. You have a BA degree from UCT
Yes, BA Law.
and then BA Law.
Yes.
That's not what your questionnaire says. You just said BA. And an LLB from the University of the Western Cape.
Yes, LLB from the University of the Western Cape.
All right. You were an attorney between 1995 when you started your articles until 2002,
Yes.
and then went into the magistracy. Your form says you were an additional magistrate from 6 May 2002, and then lists the ranks through which you went in the magistracy. But then it stops in March 2015 when you were a regional magistrate, and speaks about your acting stints as a judge. Does that mean between March 2015 and 2021, you've remained a regional magistrate, or you stopped working because...
No. I am, apologies for that.
You're still a regional magistrate.
I am a regional court magistrate, and I listed, simply listed the acting appointments in 2021, 23, and 24.
So it's March 2015 to date?
Yes, to date.
All right. Okay. And you've acted periodically since 2021 until this year?
Yes, that's correct. I am currently acting.
Or you are acting as we speak?
Yes.
In this division to which you seek employment?
Yes, in the Western Cape High Court.
You've applied. All right. And how long have your acting stints, what do they amount to?
They amount to, in total, it would be 8 terms, and again, currently 8 weeks. On my calculation, it comes to about 1 year and 8, or 1 year and almost 9 months. So that's the total period from 2021 to currently, as at today's date.
All right. When did you start acting?
I started acting in the,
You say you're acting now?
Yes, I'm acting now.
Since when?
So I started acting in April of last year, so the second term of last year. And I continued acting, but the first term of this year was not a full term.
All right. You went back?
I was in the regional court, yes, when I'm not acting.
You don't have any parted matters
No,
in your regular job?
No. So in my latest note, if Chief Justice, if you received it, that I sent, I think over the weekend, I do indicate that I currently have no more regional court matters. At the time of my application, I had a divorce parted, which was argued during the recess, and I then delivered judgment a couple of days later, and that matter's finalized. So that was my last regional court matter.
Okay. What kind of work did you do as an attorney?
As an attorney, the majority of the work I did was criminal, but I also did civil work, family law matters, and administration of deceased estates. But the bulk of it was really criminal work.
So that's your area of expertise?
It was during the period that I was an attorney.
In the High Court, you do all the work?
Yes. So I've been fortunate also a few terms ago to have been given an opportunity to do pre-trials, civil as well as criminal. I think the only work I haven't done in the High Court would be shipping and tax, but I've been exposed to quite a variety of matters.
You've sat in motions, opposed
Yes.
and unopposed, and civil trials?
Yes.
And appeals?
Yes.
Okay. and written judgments.
Yes, I have 84 written judgments over the period that I started acting in 2021. I can't give you an exact figure on my extempores, but it would be over 20. But it's 84 written judgments.
And they cover the spectrum, civil and criminal.
Yes.
I see that you spearheaded the introduction of civil regional courts.
I was, it was with the regional court president, myself and two colleagues, the one colleague being Judge Lekoleni at the time. So we were invited to act in the regional court at the time when the new regional court, civil courts commenced. And we had civil experience, and we also had experience in divorce matters. And I think hence we were requested to spearhead and train existing regional court magistrates who had criminal experience in divorce matters.
Do you have any judgments, outstanding judgments reserved for more than 3 months?
I have one at the moment that I'm busy with.
Older than 3 months?
It's a few days after 3 months, and I'm delivering it in this month, in October.
All right. Acting Judge President Goliath.
Thank you, Chief Justice. I've observed your career trajectory. It appears as if you have quite substantial experience within the magistracy following your period as an attorney.
Yes, Acting Judge President, I've been, on my calculation, if we count from 2002, it's about, I think, 22 and a half years as a magistrate. The last 14 years, if I count my acting period, it would be acting in the regional court, that is. So the last 14 years would be in the regional court, acting as well as permanent, yes.
So you started out 2021, and then you went back to the magistracy, and you came back 2023 and 2024. How did that impact on your development as an acting judge?
I would definitely, so in 2021 I had 3 terms, and I recall in my first interview, some of the comments were that I needed more experience, and I'm very grateful to have been given that experience since last year. And so I've been exposed to, I think, a wider variety of matters, and been given the opportunity to apply myself in some complex matters. So it has definitely provided more experience and growth as well as an acting judge.
How many reported judgments do you have?
I have, I checked recently, and I now have one more, so I have 7 reported judgments. One I have to qualify is a judgment that's co-written with Justice Henny. There is another matter, another judgment where AJP, you and I sat together, but you were the scribe, so I have not included that in my total of 7.
Were any of your matters overturned on appeal?
Thus far, no. 3 went on appeal, as I've indicated. In 2, I granted leave to the SCA. Both appeals were dismissed. And in another matter, I refused leave. The SCA was petitioned, and that court then granted leave to the full bench. And the full bench heard the appeal, and judgment was delivered, I think, in February. And that appeal was also dismissed. So I'm not aware, on my research, as well as with the assistance of the researcher at court, I'm not aware of any current appeals pending in respect of any of my judgments.
What was your experience with regard to the support provided by the judges in the division, the support provided to acting judges?
I think if I can put it this way, I think the judges, all the judges at the Western Cape High Court, should be commended. They have assisted me, and not only me, from my observations, other acting judges. They are always available to assist. I have had occasion where, for example, on a motion court day in the morning, something has cropped up and I needed to run something by a judge, and the judges avail themselves. So I think it's exemplary, and for anyone who starts acting there and who continues to act, all the judges have been of assistance, whether you sit with them in appeals or not. So I've had a very good experience, and that experience continues.
You were involved in SAJA training?
Yes, I can't recall if I volunteered or if one of the regional court presidents had put my name forward. It was quite a while ago, and I was a facilitator for SAJA, particularly during my regional court years, and mainly in respect of civil procedure, civil matters, and matrimonial matters and divorces.
Thank you very much, Chief Justice. I would just like to place on record that there was an issue raised regarding 2 late judgments. Myself and the ADJP were apprised of the circumstances, and I wish to place on record that the circumstances were extraordinary, which resulted in 2 late judgments. Thank you, Chief Justice.
Thank you, AJP. She had an emergency family situation, as you understand.
Yes, that is correct.
No, thank you. Mr. Boshoff?
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
So the Western Cape Division is, given its location, it's burdened with quite a heavy administrative law caseload. So I just want to ask some questions on that front. Let's say an unsuccessful candidate were to approach the Commission and say, I want access to your records and your deliberations, etc. But instead of relying on PIA, they rely directly on Section 32 of the Constitution, which guarantees the right to access to information. Would that be appropriate? And let's say we refuse. This Commission still refuses. And the candidate were to go to court, and they then, would it be appropriate to rely solely on Section 32 rather than PIA as the source for their right?
I would say in the circumstances, they would first have to exhaust PIA. I would say that they would not, let me perhaps put it, there's a tier in terms of which there are principles, there are remedies, there's legislation available. So if PIA is the legislation available for them, then that would be the first avenue available to them, as opposed to the protection of their right in terms of the Constitution sort of immediately. So that would be my answer to your question.
Yes, no, thank you. And courts have commonly referred to that as subsidiarity.
Yes.
Yes, all right. My next question then is, a private developer has a piece of land, a municipality identifies it and sees, listen, we would like to purchase this land from you because we have human settlements need. Let's talk, they make a price, they come to an agreement. conclude an agreement, then subsequently arises that, it comes to the fore that the municipality, there was no council resolution in terms of, as required by the MFMA, for example. And the municipality now says, sorry, we want out. The developer or the landowner then runs to court and says, I want to hold the municipality, I want the court to enforce this agreement, and I'm relying on estoppel. Because as an innocent third party, or they can't, they can't raise their own shortcomings, and if that were to fail, then I'm also going to rely on the so-called Turquant principle, because as an innocent outsider, I'm entitled to act, on a bona fide reliance that they've complied with their internal processes, etc. Would a court entertain such an approach? Or maybe that's poorly stated. Would such an argument hold in law from the developer now?
I think the Turquant rule is there to protect the third parties, or a third party, in respect of the conclusion, let's say in this instance, of a contract with the developer. It would therefore mean that they can assume that the developer has...
Sorry, just
remember,
it's the developer invoking this now in
the
court.
developer is invoking it.
The developer is saying, I don't care what you complied with and didn't comply with. I assumed in good faith you did comply with it. Therefore, I'm relying on the Turquant principle. I'm asking the court to enforce this contract because of my reliance.
I would say that the Turquant rule is available to them in the circumstances in light of the circumstances that you have raised.
Can I perhaps then just clarify that? I'm anticipating my fellow commissioners follow.
Yes.
Put more plainly, can a court, through estoppel or the Turquant rule, enforce an action that would otherwise amount to an unlawful act by the municipality, or something ultra vires, beyond their powers normally?
No,
Okay, that's fine.
that would be my answer.
Thank you.
Commissioner Matthias?
Ms Pangarker,
Yes, good day.
thank you for coming.
Thank you.
I understand that you have done a lot in terms of mentoring and assisting juniors in the bar. Can you elaborate on this?
May I-
Your commitment to transformation.
Yeah, Commissioner, may I just ask, are you speaking about juniors in the legal profession?
Yes, yes.
So I can start by saying the following. I think my commitment started way back when I was a candidate attorney in the 90s, 1995. At that stage, at Legal Aid, I was at Legal Aid for a while, and I then assisted two more junior candidate attorneys, if I can put it that way. And at the time, in the criminal courts where we were based, Afrikaans was the language that was spoken by accused persons in court. So I had assisted them. I assisted them in the drafting of guilty pleas, consultation with their clients, and to such an extent that these colleagues were able to adequately then conduct proceedings. I'm not saying that there were no interpreters, there were interpreters, but it was in a period where English was not the language of record yet in courts. And if I were to move a bit forward, and these colleagues of mine have now themselves become, I think, magistrates, and the one colleague I know had acted as a magistrate, and they were not from the Western Cape. And as a magistrate, what I have done, and it's something that I continue doing, I think the passing on of skills and upliftment is something that occurs within the courtroom. So I would have candidate attorneys who have just obtained the right of appearance in the regional court, and it's a civil regional court, for example, and they would, for example, come with a few questions that they would ask a divorced client. And in many instances, it would not be sufficient, and before I can finalize a divorce, I would obviously need to know that, and be able to find that a marriage is broken down irretrievably. And so I would assist in that fashion. And on many occasions, these candidates would remain in the courtroom, and I would later on be informed, well, we've learned a lot from you simply just sitting in court and learning about civil procedure and matrimonial matters.
Okay, thank you. You have answered my question. Thank you,
very
CJ.
much.
Commissioner
you,
Godson?
Thank you, CJ. Good afternoon, Ms.
Good
Pangarker.
afternoon, Commissioner.
You list as one of your reported cases a matter involving Mr. Kulu and his law firm.
Yes,
It's the contempt of court matter, which was based on the misappropriation of large sums of money
yes,
from the Department of Environmental Affairs. Now, you were tasked with this very sensitive matter early on as an acting judge, and you concluded it without fear or favor. Given the preceding Mulahutsi judgment, which had at that stage already shone the light on the judge president's conduct in favor of his attorney, did you have any apprehension that finding Mr. Kulu guilty of contempt may have an adverse consequence on your professional career? And I say this because in the context that Mr. Kulu had at the time also pursued JSC complaints against the judges who had made rulings against him prior in that litigation, including Constitutional Court Judge Owen Rogers.
yes. So, Commissioner, you are quite correct that, if my memory serves me correctly, I started acting in January 2021. I was the urgent duty court judge for 3 days in a row, and that matter landed in my lap. I was acting for about 5 weeks at the time that matter came before me. And I think if I could put it, and I don't mean any disrespect, colloquially, there was a lot of noise about it. I believe, if I recall, it was reported, it received media attention. And if you read my judgment, you would also see that at some stage in the proceedings, I had been informed that I can't hear the matter, something to that effect. That aspect is dealt with in the judgment as well. At the time, to answer your question, no, I did not have any fear or idea that this would affect my further acting prospects. I dealt with the matter, obviously aware that at the time this was the judge president's attorney, he had represented him, and I, for want of a better word, divorced myself from outside noise, from any media reports or anything to that effect. I do all my judgments at home as far as possible, and I had practically locked myself up and without any outside noise. I then delivered the judgment, and of course, at that stage, I believe there were comments and feedback, and people had come to me with their own views about the judgment. If I can describe it further, that was a moment where I must say that when the judgment was sent out, I had this idea that, yes, it could possibly affect my acting potential at some stage. But I went ahead and did my job and what was required of me. Who was involved or not involved was not an issue for me. And because everybody is treated fairly and the litigants in that matter were all treated with respect, as I always do, I think it was only afterwards that when I heard people's views on this matter and the fact that I delivered such a judgment, some were of the view that, well, this is a very brave thing to do, being an acting judge at the time in this particular division. And I actually didn't really appreciate it at the time. But whether it affected my acting prospects then, I can't really say. I was later on invited to act again. Sometimes I think there comes a time, and I can only speak about my own career, where you walk into court and you know for a fact that you are going to dispense justice without fear, favor, or prejudice. You are going to uphold the rule of law, as I did in that matter, and you are going to uphold the provisions and the principles of the Constitution. But there's perhaps a slight, I don't know, you know that there's going to be some kind of effect, potentially. There was an indication of, oh, I will be reported to the JSC for delivering a judgment like that. And so I had to do what I had to do, and I had to acquit myself of my judicial responsibility, which is what I did. And I would like to think, as somebody had said to me, an advocate at the time, that what I did was actually courageous as a judicial officer, and particularly, I think, an acting judge in that division. It's not how I saw myself, but that was one of the comments. So I hope that answers your question.
Thank you, Ms. Pangarker.
Thank you very much.
CJ, just a follow-up on that? Sorry, just very briefly. I can't remember. It's, I tried to check now, but it's coming back to. There was a leave to appeal application, yes. But was it ever prosecuted?
The leave to appeal, and I checked because I think one of the commissioners asked me on the previous occasion about it. So the judgment and the orders were against Mr. Kulu and then his firm. So I had refused leave to appeal, and I went to the SCA. The SCA refused leave in respect of Mr. Kulu, but it had granted leave in respect of BXI, his firm. My further understanding is that the appeal had then lapsed. That is, when I completed my questionnaire for this interview, that was the latest information that I had.
Thank you.
Thank you.
Commissioner Marumachai?
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
Earlier on, when you were speaking, you referred to one of your judgments that was taken on special leave to appeal, but leave was granted to the full court of the High Court.
Yes.
Yes. I'm not going to ask you about that judgment.
Okay.
There's a principle that comes out of that scenario that I want to ask you about, that arises directly from the rules.
Sure.
Rule 4913, you don't need to know this, I'm just giving you context so that you understand the question.
Sure.
Rule 4913 of the Uniform Rules of Code, it dictates that when somebody has been granted leave to appeal, they need to furnish security for costs, or they can be exempted upon request to furnish those securities. But when the judge that leave to appeal is sought from refuses leave to appeal, and then they have to petition the Supreme Court of Appeal, and then the Supreme Court of Appeal grants leave to the full court. In that situation, is the person who's successful at the Supreme Court of Appeal and who was not successful at the High Court with a single judge obliged to furnish security for costs? I'm not sure, do you get the question?
Do you mind if I ask you just to repeat the last part for me,
The last
please?
part is, Once leave has been refused by a single judge
Yes,
in the High Court, and then the person is not happy with that decision, then petitions the
Yes.
Supreme Court of Appeal, and the Supreme Court of Appeal grants special leave for that person to appeal to the Supreme Court of Appeal. Then the Supreme Court of Appeal says, we are not going to hear this appeal. Go back to the full court, which should then hear the appeal. Under those circumstances, is the person who is successful at the Supreme Court of Appeal obliged to furnish security for costs?
I would say no. I think the outcome, one would need to determine what the outcome is of the appeal. So in those circumstances, I would say no, he's not obliged to pay security for costs at that stage.
Okay, no, thank you very much. Thank you very much, CJ.
Commissioner Hassan, is it a follow-up?
Thank you very much, CJ. I'm over here. Thank you. I want to ask two questions. The first is, what is the difference between reading in and reading down of a statute by the court?
I would say that reading in would be a question of interpretation, adding, or perhaps not adding, but depending on the circumstances that one's dealing with, I would say that reading in would be where one interprets the statute in a certain way, depending on circumstances which prevail in a particular matter. Reading down, I'm not entirely sure, but I would say that reading down would be where you are excluding something from the statute or from an interpretation process.
May I?
So may I follow up on this?
Sure.
Can I have, I mean, I'm not too sure if I get to correct. Of course, we are correct that this is often referred to in the interpretation of a statute where you are invalidating or you are saying a statute. So would I be correct to say reading in would mean you read in some words that are not there, where the intention of the statute you can understand, but there are some words that are not, there are gaps in the statute. Is it not such a situation?
I would think, but I would think that one would need to qualify, and that it's not to an extent that the meaning of the statute or the section is changed. That would be my understanding of it.
No, let me follow up with this because I'm not sure what is going on now, Ms. Pangarker. You see, there are various remedies that a judge can give in a constitutional challenge, correct?
Yes,
And
thank you.
the power comes from Section 172 of the Constitution, correct?
Yes,
Sometimes you can say that I hereby declare that Section 20 of the Sexual Offences Act is unconstitutional. Parliament must fix it. And you do nothing else, correct? That's one possibility.
that is a possibility.
Yes, and then sometimes you can say, no, I don't have time to wait for Parliament to fix it. I need it to be fixed now. Correct?
Yes,
And then in those circumstances, then the judge will provide his or her own words in the statute, how the statute must be understood from that day onwards. Correct?
I follow you, Commissioner, yes.
And then, so there is a term for that. When a judge is doing that, there is a term for it. So, and it's self-explanatory. He's reading into the statute his own words. So isn't that reading in?
In the explanation that you've given, I would have to agree with you,
Yes. Now,
Commissioner.
there is then another scenario The judge looks at the statute and says, no, 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 I don't want to make any declaration of any invalidity, but I want to interpret it narrowly so as to limit its scope or limit its impact or limit its effect. I'm not adding anything, it's there, but I'm defining what it means. And doesn't the judge have the power under Section 39 of the Constitution to do that?
Yes, and that, I would say in terms of Section 39, the judge would also have, depending on what it is, extending the common law, if it is
No,
not.
let's forget about the common law now
Okay.
because we have to answer Commissioner Hassan. So when the judge is now interpreting narrowly the scope of a section, there is also a technical term for that. Isn't it reading down?
Then the judge would be reading down.
Yes, so then isn't that the answer to both of those questions?
Yes, thank you,
Which means
Commissioner.
that you understand both of them. Thank you.
And colleagues, what Commissioners Nokesi and Nokai Toby have just done is what takes time. When a candidate gives an incorrect answer, whilst the exercise is educational, you want to put them through the paces and give them the right answer, and that takes time. And you complain that we delay things. Thank you.
CJ, may I ask my last question? Quickly?
JP Mlambo.
CJ, may I ask my second question just before? Through you?
Okay.
Thank you. My second question is whether the court is entitled to reject an expert opinion, and if so, under which circumstances?
Yes, the court is not bound by expert opinion. Ultimately, the court is in the best position to make a determination insofar as evidence-led where an expert is called. I think one must take into account the nature of the expert evidence given, the particular area of whatever the subject is that the expert is testifying about, how the expert logically came to his or her conclusions, and what basis and what material, if I could put it that way, the expert has relied upon. But ultimately, the fact that one calls an expert to come and testify does not necessarily mean that you're bound by the expert's testimony and that you have to accept it. I can also probably add that, you know, how the witness fares in the witness box and under cross-examination is also a determination that you must take into account. Thank you.
Did have my question, CJ.
No, you've exhausted your quota, I'm afraid. We still have two candidates to interview.
I accept.
Commissioner.
I'm not going to say anything. Thank you, Chief Justice.
Thank you. Thank you, Ms. Pangarker. You're excused.
Thank you very much, Commissioners. Thank you.